Ready, start. Wherever any body of persons within bracket 1 having legal authority within bracket 2 to determine questions affecting rights of subjects and within bracket 3 having the duty to act judicially within bracket 4 act in excess of their legal authority dash a writ of certiorari may issue full stop. It will be seen from the ingredients of judicial act that there must be a duty to act judicially. Full stop. A tribunal, therefore, exercising a judicial or quasi-judicial act cannot decide against the rights of a party without giving him a hearing or an opportunity to represent his case in the manner known to law. Full stop. If the provisions of a particular statute or rules made thereunder do not provide for it, principles of natural justice demand it, full stop. Any such order made without hearing the affected parties would be void, full stop. As a writ of certiorari will be granted to remove the record of proceedings of an inferior tribunal or authority exercising judicial or quasi-judicial acts, it follows that the High Court in exercising its jurisdiction shall also act judicially in disposing of the proceedings before it, full stop. It is implicit in such a proceeding that a tribunal or authority which is directed to transmit the records must be a party in the writ proceedings, for, without giving notice to it, the record of proceedings cannot be brought to the High Court, full stop. It is said that in an appeal against the decree of a subordinate court, the court that passed the decree need not be made a party, and on the same parity of reasoning, it is contended that a tribunal need not also be made a party in a writ proceeding, full stop. But there is an essential distinction between an appeal against a decree of a subordinate court and a writ of certiorari to quash the order of a tribunal or authority. In the former, the proceedings are regulated by the Code of Civil Procedure, and the court making order is directly subordinate to the appellate court and ordinarily acts within its bounds, though sometimes wrongly or even illegally, but in the case of the latter, a writ of certiorari is issued to quash order of a tribunal which is ordinarily outside appellate or revisional jurisdiction of the court, and the order is set aside on the ground that the tribunal or authority acted without or in excess of jurisdiction. Full stop. If such a tribunal or authority is not made party to the writ, it can easily ignore the order of the High Court quashing its order, for, not being a party, it will not be liable to contempt. Full stop. In these circumstances, whoever else is a necessary party or not the authority or tribunal is certainly a necessary party to such a proceeding. Full stop. In this case, the Board of Revenue and the Commissioner of Excise were rightly made parties in the writ petition. Full stop. The next question is whether the parties whose rights are directly affected are the necessary parties to a writ petition to quash the order of a tribunal. Full stop. As we have seen, a tribunal or authority performs a judicial or quasi-judicial act after hearing parties. Full stop. Its order affects the right or rights of one or the other of the parties before it. Full stop. In a writ of certiorari, the defeated party seeks for the quashing of the order issued by the tribunal in favor of the successful party. Full stop. How can the High Court vacate the said order without the successful party being before it? Full stop. Without the presence of the successful party, the High Court cannot issue a substantial order affecting his right. Full stop. Any or that may be issued behind the back of such a party can be ignored by the said party, comma, with the result that the tribunal's order would be quashed, but the right vested in that party by wrong order of the tribunal would continue to be effective. Full stop. Such a party, comma, therefore, comma, is a necessary party and a petition filed for the issue of a writ of certiorari without making him a party or without impleading him subsequently, comma, if allowed by the court, comma, would certainly be incompetent. Full stop. A party whose interests are directly affected is, comma, therefore, comma, a necessary party. Full stop. In addition, comma, there may be parties who may be described as proper parties. Full stop.